Hi there, and welcome back to Immigration News and Views from the Nachman Pawani Zimochek Law Group. That's the NPZ Law Group. My name is David Nachman. I'm one of the managing attorneys at the NPZ Law Group. We have offices in Ridgewood, New Jersey, in Manhattan, New York. We have affiliated offices in Mumbai, India, and also in Canada. I come to you today to discuss an area of EB-2 classification for the green card. It's called the National Interest Waiver. The National Interest Waiver came into the law back under the 1990, it's actually called IMACT 90, and came into law in 1991, early 1991. And the National Interest Waiver is sort of a special classification. It's special insofar as, number one, you get EB-2 classification. So there is a distinction, and I've mentioned it before on some of our previous videos, that of course you have EB-1 classifications. EB-1s are very good because the priority dates generally are always current. EB-2s are, while for some countries they're backlogged, they tend not to be backlogged as badly as the EB-3 cases, which are the professional cases that unfortunately for India and China get backlogged tremendously. Now in the EB-2 classifications, India and China also are backlogged, at least with regard to the monthly visa bulletin, but the EB-2 is not backlogged as much as the EB-3. So EB-2 often is one particular option which we'll discuss with our clients that have special needs. The special needs being, one, perhaps their organization either will not or cannot sponsor them. There's some organizations that actually won't do sponsorship, in which case, of course, the individuals are left to self-sponsor if they're looking to advance their priority dates. So the two options would be an EB-1 extraordinary ability case, which we'll discuss in a video in the future, or EB-2 national interest waiver. Now, the national interest waiver classification, when it was originally implemented, basically just said that if you are doing something that is in the nation's interest, that would be sufficient. And I remember back in the early 90s, there was a New York Times article that a lot of the Soviet scientists who had immigrated over to the United States, who were actually not working in their fields, ended up filing under this national interest waiver and said that the work that they were doing is in the nation's interest, and some of these cases were approved. Well, the Immigration and Naturalization Service at that time realized that there were some deficiencies in the legal standard, and so there actually was a case called Mississippi Phosphate. And the Mississippi Phosphate case laid out for us some very clear guidelines in helping us to understand what is in the nation's interest. So one of the things that's in the nation's interest is improving health care in the United States. So that's something that's in the nation's interest. So if an individual is working in the healthcare field, then of course, possibly, the national interest waiver is an option. Also, improving wages and working conditions for U.S. workers is also considered to be in the nation's interest. And another area that's in the nation's interest are doctors who are working in medically underserved areas. In fact, there's a memorandum, an internal memorandum, which basically sets forth that that is in the nation's interest. And there are a couple of other areas like improving housing and urban development for the United States, and that's included in those things that are in the nation's interest. I guess one additional area which we would obviously put forth now is that if you're adding jobs through entrepreneurship, that is also in the nation's interest, and it ties probably very closely with the new program that's being promulgated by the USCIS called Entrepreneur in Residence. If you're not familiar with the Entrepreneur in Residence program, I would encourage you to go to the website at www.uscis.gov and click on the icon that discusses the Entrepreneur in Residence program. Because in fact, you can make a pretty good argument that entrepreneurship and the development of jobs for U.S. workers through investment is considered to be in our nation's interest. One other thing that we turn to determine whether or not someone is working in the nation's interest is whether or not there's a government administrative agency that is actually doing something or has some kind of a policy that is coincidental with the services that our EB-2 applicant or petitioner is potentially going to be doing. Now, that's the first thing that we want to look at is, number one, is it in the nation's interest? The second thing that we want to look at is whether or not the individual is exceptional in his or her field. Now, the definition of exceptional, just by rule of thumb, is an individual who has a master's degree or its equivalent, or if it's an individual who has notoriety or an extremely great amount of experience in their field of endeavor. So that might be a way to prove that an individual has exceptional ability in the field. So for many years we were putting together these national interest waivers, and by the way, just to give everyone a sense of what that package looks like, it's an I-140 petition that's done by the individual, and you can choose self-sponsorship, of course, as I mentioned before. However, it can also be a petition that's sponsored by a U.S. employer. And that, of course, adds a good amount of strength to that type of petition. In addition, there is also a labor certification requirement. You have to fill out a 9089, but you're not submitting that to the Department of Labor. You're submitting that as an application to accompany the I-140, and what you're doing essentially is you're asking the USCIS to grant a waiver of the labor certification process. So what it is it's a petition for an alien with extraordinary ability, and it's an application for a waiver of the labor certification process. So that's really what the package is composed of. So our office does a lot of national interest waivers. Many of them are, of course, for individuals who are in academia, for professors, for researchers, for scientists, for doctors, but also you can use a national interest waiver, of course, in the private sector, in organizations where individuals, of course, have the types of evidence that would bear out a good national interest waiver case. So what would those types of evidence be? Well, for example, one might be a good amount of documentation where, let's say, the individual is prolific and has written extensively in their field. And of course, through those writings, become recognized as a leading authority. That's one particular thing that we would be looking for. Also, awards. That's a terrific piece of evidence if an individual has awards or recognitions. Also, we look for patents. If an individual has patents or some type of contribution of original scientific data to the field. We also look for whether or not the individual is being paid a very high salary, because that, of course, goes to the fact that the individual has exceptional ability in their field of endeavor. Now, oftentimes, when you're dealing with a situation where an individual is in an academic institution, then that type of compensation may not necessarily be borne out. However, you can use an argument, which we often use, of called psychic remuneration. The individual who's going to work in academia, they're not looking necessarily for a lot of money. What they're doing is they're looking for the good feeling that they get by being able to engage students and to teach their trade. So that could be one of the arguments that's used to offset, let's say, a lower, a lower level of salary. So as time marched on, and this happened, I guess, much later in probably the late 90s, early 2000, there was another case that was called the New York State Department of Transportation, and that case also helped give a little more guidance about this process, about the national interest waiver. And so we get, and it actually erected a much more difficult hurdle for individuals to be able to get the national interest waiver, because what we had to do is we actually had to prove that there was that the nation's interest in the labor certification was outweighed by the benefit that one would be able to obtain the waiver of the labor certification process. So that made it a little more difficult to get the national interest waiver, but again, by looking at the evidence and as a whole, and really what the legal standard is a totality of the circumstances. We take a look at all of the evidence that our clients present to us, and we make a determination as to whether or not the best route for them to go might be an EB-1, might be EB-2, or of course might be an EB-3. So of course individuals who have a tremendous amount of these materials that I mentioned to you before may qualify in the EB-1 classification, or they may be classified as national interest waivers. If they don't have that type of information, then of course we would probably be looking more toward the perm labor certification process for them. So that's a sort of an overview of the national interest waiver classification. I hope it's helpful to you if you're thinking about the national interest waiver, trying to figure out how you want to proceed with regard to the green card. Our office handles green cards in all of the employment-based visa classifications. And the most important thing that we can do for you is to sort of look at everything that you have together. It's the reason why we usually start off by asking you for a resume. We'll review the resume, and then what we'll do is help you see the full spectrum of green card cases that are available to you. Thanks so much for joining us today. We really appreciate it, and we look forward to being able to provide you with additional information about green cards, business immigration, and family-based immigration in the future. Thanks so much for joining me today.